start speaking on the topic, that is the competition and corruption, balancing the two concepts in public procurement disputes in Pakistan. And in this seminar, I shall attempt to highlight and deal with the topic that competition and corruption, the subject matter, that how it dealt with the procurement laws. Those were enacted to protect the public exchequer and to have a transparent purchases that has been made on account of the public at large in this country. And I shall try to highlight the importance of having just, fair and transparent competition in the market, and would highlight as to how the lack of genuine competition increases the risk of corruption. And further, there would be at the end would be kind of a few suggestions that how the laws could be made even more appropriate so that the risk of corruption could be kept at minimum. So first of all, the way public procurement laws are drafted is in a way that they are divided into two categories. First is the form of statutes and the rules that are governing their functioning of those statutes. Since Pakistan, after 18th Amendment, every province has dealt with the subject matter in their own manner, and for that reason, there exist various acts for all the provinces and to deal with their own procurement as well. It includes Public Procurement Regulatory Authority Ordinance 2002, which is with regards to the establishing a regulatory authority for the purposes of federal institutes and the procuring agencies. The next is Sindh Public Procurement Act 2009, Balochistan Procurement Regulatory Authority Act 2009, Punjab Public Procurement Regulatory Authority Act 2009, Khyber Pakhtunkhwa Public Procurement Regulatory Act 2012, Azad Jammu and Kashmir Public Procurement Regulatory Authority Act 2017. And their rules are also being drafted separately for each province and federation as well, and for Jammu and Kashmir as well. That includes Public Procurement Rules 2004, Sindh Public Procurement Rules 2010, Balochistan Public Procurement Rules 2014, Punjab Public Procurement Rules 2009, Khyber Pakhtunkhwa Procurement of Goods, Works and Services Rules 2014, Azad Jammu and Kashmir Public Procurement Rules 2013 as well. Though they all are, every province along with the federation is having their own rules and acts for their operations as well, but the scope and objective of all of them are similar, the same, which include the public procurement for goods, works and services, including consultancy services and public-private partnership projects as well. And the object of the rules and regulation for having rules is that the procurement brings value for money to the agency, and the procurement is done in an efficient and economical manner. So the concept that has been evolved in a various format that mostly we have come across to see or to hear from various sources as well, the way the cases have been highlighted in news and all other places as well for the bad purposes as well, so that the procurement has not been made or the public exchequer amount has been stolen or this has been, which gives a kind of a general perception that it may be that the purchase was to be done on the lowest bid and instead it has been done in a very high amount, which is not the case, because the law that deals with the procurement law require to understand the concept of value for money. Value for money is best written for each rupee spent in terms of quality, timeliness, reliability, after-sale service, upgradability, price, source, and the combination of whole life cost and equality to meet the procuring agency's requirement. Whereas in theory it has been defined as value for money is about striking balance between three E's: economy, efficiency, and effectiveness. It is not a tool or a method, but a way of thinking about using the resources as well. So the definition that has been given or the requirement that is there is value for money does not explicitly state or define or suggest that there has to be one way to deal with it. It requires the procuring agency to understand the purchase that they are doing, the way they want to use these things, and what would be the need behind it. So it's a kind of a thing which goes subject to subject in terms of procurement. But for the overall procurement, there exist principles as well amongst all the rules that has been drafted across the country, which require a twofold strategy. That is, the procurement must be done in a fair and transparent manner. So this is what the Pakistani laws across the country are defined. However, if we look across different legislations or the strategies that have been defined, for the purposes of understanding, I have referred to the 5 areas as a principle that has been identified by the United Nations for the purposes of procurement. They talk about 5 points. First, the principle would include best value for money. Second, it would include fairness in procurement. Third, fairness, integrity, and transparency. Third, it would require effective international competition. Fourth, the interest of the contractor. Fifth, client centricity. Now, the reason, the third point, I would stop here and would address this effective international competition. Since the United Nations is an agency that deal with the kind of work that involve various different sovereign states, and the way they do procurement involve mostly the international suppliers who provide goods, services, and work. So for that reason, they have relied for this effective international competition. Whereas in our national or the domestic laws, the reliance has been placed on both international and national competition as well, for the purposes that when the things are being purchased in public procurement, it is not necessarily all the time that the international competition is to be required, or the things have to be purchased which are not being made by the local manufacturers or the goods provider. And there is one more jurisdiction, that is of the New Zealand as well. They include one more point in that, and that includes the accountability concept in their principles of procurement as well. So this is something which is left over the states to define as to what do they think as fit for the purposes of ensuring that the procurement process is done in a fair manner. The definition of competition is not been given in a general form in any of the procurement law, but has been referred as open competitive bidding, which states as a procurement method in which offers from the competing suppliers are invited by open advertisement with the scope, specification, and terms and conditions of the proposed contract, as well as the criteria by which the offer will be evaluated. The objects of competitive bidding are to obtain goods or services at the lowest cost or best value through open and fair competition. Now, this once again include the word the lowest cost as well, or the best value, the concept of best value as well, which includes the veracity of the challenges that the procuring agency or the supplier has to face, subject to what they are about to supply or what the procuring agency is about to purchase. And the corruption is, as per the recent Corruption Perception Index, Pakistan is ranked as one of 140th ranking out of 180 countries, and we have seen that the government activities are more vulnerable to the corruption. According to the survey that was published by the OECD, Organization of Economic Cooperation and Development, which includes various European countries, and it includes 38 countries in their list of organization. As per their report, they have done 4.2 trillion business, and their procurement was accounted for 12% of GDP and 29% of government expenditure. Pakistan's report were pretty much similar to the same figures that are given by the OECD, with a slight difference of 15%, excluding the military procurement that has been made, because normally they are not even accounted for, so not many people know about their purchases. The concept of corruption is generally covered under various connotations in these rules, and they are divided into 4 categories in public procurement. First, it would include the coercive practice, collusive practice, corrupt practice, fraudulent practice, and fifth, that is the obstructive practice. The definition amongst all these elements for the corrupt and fraudulent practices is pretty much the same in all the legislations across the country. as per which the coercive practice is impairing or harming or threatening to impair or harm directly or indirectly any party to the property of the party, to influence the action of a party to achieve a wrongful gain or to cause a wrongful loss to another party. Collusive practice, any arrangement between two or more parties to the procurement or contract execution designed to achieve with or without the knowledge of the procuring agency to establish prices at artificial non-competitive levels for any wrongful gain. Corrupt practice is defined as the offering, giving, receiving or soliciting directly or indirectly of anything of value to influence the acts of another party for wrongful gains. The last is a fraudulent practice. Any act or omission, including a misrepresentation that knowingly or recklessly mislead to attempts to mislead a party to obtain a financial or other benefit or to avoid an obligation. All these definitions basically are of the fact that it would require the party alleging about any of these, and sorry, there is last one as well, obstructive practice as well, which states as harming or threatening to harm directly or indirectly persons or their property to influence their participation in a procurement process or affect the execution of a contract or deliberately destroying, falsifying, altering or concealing of evidence material to the investigation or making false statements before investigators in order to materially impede an investigation into an allegation of corrupt, fraudulent, coercive or collusive practice, or threatening or harassing or intimidating any party to prevent it from disclosing its knowledge of matters relevant to the investigation or from pursuing the investigation or acts intended to materially impede the exercise of inspection and audit rights provided under the rules. Now, these definitions were quite a lot similar to what we have seen in the criminal procedure code, or the way their application would be that once either during the procurement process or the post-procurement process, any bidder comes to know about the fact that any of these actions have been involved would require a high threshold to meet before the allegations could be processed, or mere allegation would not suffice the case. Apart from these the definitions that has been provided into the laws, procurement laws, the further grounds for alleging any bidding process is of different nature. They are not expressly stated in any of the rule or the regulations that we have in Pakistan. But for example, if we are to allege or to dispute any procurement process, the issue of abnormal prices is one that has been commonly being taken into the situation. For example, I would quote the example of in a health sector, we see that the hospitals do procure the food items and all other items for the utilization of patients in hospital. Now we are well aware of the fact that if you look in our surrounding, there is no fixed basic rates that could be approved for genuine procurement in terms of any food item, for example, vegetables or all these other items, despite of guarantees for the competition in our procurement laws are first that it defines the procurement principles of procurement, which has to be fair, just and transparent mechanism. Second, it is ensured by way of having an equal treatment amongst the bidders by avoiding discrimination whatsoever. And third is the constitutional right, mostly emphasized on Article 18 of the Constitution of Pakistan, which states for right to profession, right to trade and profession. For the purposes of execution of these guarantees, the laws across the country provide a twofold strategy or twofold mechanism in majority of the laws. First, there exists a redressal of mechanism concept, and then there exists an appeal. And in alternatives, once they both are exhausted or if they are avoided, the suits under the Civil Procedure Code or the constitutional petitions under the Constitution of Pakistan could be found. So the first mechanism
once the procuring agency at any stage, either at the evaluation stage, during the evaluation, post-evaluation, or at the earliest of the stages where the bid is announced and the bidder has any query or any observation of the over the bidding process and the same is declined. So the first thing that an aggrieved party has to do is to file a complaint to the same procuring agency for redressal of their grievance. Now the confusion with regards to the redressal mechanism is that it would require to file the complaint to the head of the same procuring agency which has previously declined the any complaint or any observation that has been made by the bidder. And mostly in those procuring agencies, the grievance committees that has been formed are formed by the higher-ups consisting of their own subordinate officers. So first thing that is of most controversy is that how is that even possible that a superior officer is going to pass an order that is against their own immediate higher-ups. So this would be fall as the expert in that relevant field and how that expert has passed decisions in the past. The chances for violation of rule is less in the places where there exists set of rules disposing appeals like in federal procurement law and federal institutions. It could easily be inferred as the rules do not stipulate about the mechanism that could suggest what is reasonable opportunity, how the reasonable opportunity would be afforded to any aggrieved bidder, how in the absence of any technical experts in the committee the technical disputes would be resolved, or in the event of disputes to the impartiality of technical member, what mechanism would be resorted. So these are one of the few. Mostly in cases like such where the regulatory body do receive the complaint, they also take several weeks, if not days, to constitute the committee of the redressal committee that could dispose of the appeals. And in most cases, for even getting that committee constituted or for getting an appropriate order, most of the time it happens that we have to file a constitution petition for seeking direction to the regulatory authority that the committee be constituted and the same application be disposed of in a timely manner. The reason being, once again, is the same because within a period of 12 months where procurement process and supplies and work is to be done, most of the time is left in all these procedural things, and the way delays are caused for in a situation where there exists any dispute. And in terms of the expert, any dispute arises in terms of expert or the issue that involves the expert opinion. One more, the example is that when any term or condition is alleged as difficult, this is a reference to Rule 40 of the Sindh Public Procurement Authority 2010, Sindh Public Procurement 2010, and there the same section has been referred to in all of the laws under different headings, but each law contains the same provision that if there has to be no discriminatory or difficult condition in any bidding process. But what if one of those arises? The reference is to be made to the rule requiring no discriminatory clause to be inserted in a bidding document. To ascertain the same, reference shall be made to the ordinary practices of that trade, manufacturing, construction, business or service to which that particular procurement is to be made.
और क्या प्रोसीजर है जिसको ऑब्जेक्शन होगा या कंप्लेन होगी, वो किस तरह फाइल करेगा, कहाँ फाइल करेगा, और क्या डायरेक्ट सूट या पिटीशन में भी जा सकता है वो जो ऑब्जेक्टर है, और स्टेज क्या होगी, किस वक्त वो प्रोसीडिंग या ऑब्जेक्शन फाइल करेगा.
सर रूल्स में ये चीज मेंशन है कि जब एनआईटी फ्लोट हो जाएगी तब से लेके जब तक ये प्रोसीडिंग्स कंक्लूड नहीं होती, अगर इसके बीच में कोई ऑब्जेक्शन या क्लैरिफिकेशन कोई बिडर अगर करना चाहे तो वो इन रिटन फॉर्मेट जो है प्रोवाइड कर सकता है. जहां तक बात है क्लैरिफिकेशन की, तो उसका तो कोई फॉर्मेट प्रोवाइडेड नहीं है, वो सिंपल फॉर्मेट में दी जा सकती है. बाकी जहां तक बात आई कंप्लेन की, कंप्लेन किस फॉर्मेट में होगी और किस तरह होगी, तो इसका बेसिक आइडिया हर रूल के अंदर प्रोवाइडेड है. सिर्फ खैबर पख्तूनख्वा कंप्लेन रिड्रेसल रूल्स और एक है पाकिस्तान पब्लिक प्रोक्योरमेंट ग्रीवेंस रूल्स, ये दो रूल्स ऐसे हैं जो تھوڑا سا ایکسپلیسٹلی ڈیفائن کرتے ہیں کہ کمپلین کس فارمیٹ میں آئے گی, اس کے بعد جو ہے کیا نوٹسز کس طرح ایشو ہوں گے اور کس طرح جو ہے پارٹیز کو ہیئرنگ کی اپرچونٹی دی جائے گی. یہ ان دو میں صرف پرووائڈیڈ ہے, باقی کسی میں یہ پرووائڈیڈ نہیں ہے کہ کس طرح دینی ہے. صرف بیسک سا دیا ہوا ہے کہ کمپلین کس بارے میں ہے, کمپلین کی نیچر کیا ہے اور یہ سب کرنا ہے. اور باقی سر کمپلین پہلے اسٹیپ میں پروکیورنگ ایجنسی کے ہی پاس ہو فائل ہوگی. پروکیورنگ ایجنسی پھر کانسٹیٹیوٹ کرے گی گریوینس کمیٹی. اس کے بعد ان کے پاس ٹائم ہوتا ہے کہ ودن 3 days وہ نوٹیفائی کریں گے کمیٹی. 3 دن کے بعد جب نوٹیفائی ہوگی اس کے بعد 7 دن کے اندر انہیں کمپلین جو ہے ڈیسائیڈ کرنی ہے. اگر 7 دن میں کمپلین ڈیسائیڈ نہیں ہوگی تو آٹومیٹکلی اٹ وڈ بی ٹرانسفرڈ ٹو دی ریگولیٹری اتھارٹی. تو 7 دن کے بعد 10 دن کے اندر ریگولیٹری اتھارٹی کے پاس اپنے کمپلین اپیل فائل کریں.
ٹیکنیکلی بھی وہ نہیں دیکھ سکتی اور جو ہے کانٹریکٹ ایوارڈنگ کا پاور بھی کورٹ کو نہیں ہے. تو واٹ گریونسز وی کین ٹیک فرام دا کورٹ, واٹ کائنڈ آف ریلیف وی کین ٹیک فرام دا کورٹ. کیونکہ اگر وہ ہو چکا ہے, لا تو یہ کہتا ہے کہ کورٹ از ناٹ ہیو نو اتھارٹی ٹو گرانٹ اینی ایوارڈ یا ایوارڈ اینی کانٹریکٹ. تو یہ کیا ریلیف لینے جائیں گے کورٹ سے؟
سر اس کی 2-3 صورتحال ہیں. اگر مثال کے طور پہ ڈیورنگ ڈپینڈنسی اگر آپ اس کو چیلنج کرتے ہیں کسی کورٹ میں تو اس کے اپنے کچھ گراؤنڈس ہیں. جیسے کہ ایک میں نے بتایا کہ اگر پرائسز کا ایشو ہے تو ابنارمل پرائسز ہیں. ابنارمل پرائسز میں ریٹ انفلکچویٹ کرتا ہے آئدر ان ایکسٹرا آرڈنری مینر, اوپر کی طرف جاتا ہے یا بالکل نیچے کی طرف جاتا ہے. تو وہ تو اگر کوئی ایسا پروڈکٹ ہے یا کموڈٹی ہے جو کہ ریگولیٹڈ ہے بائی دی اسٹیٹ ان ٹرمز آف پرائس, تو وہ تو ڈٹرمن ہو سکتی ہے کورٹ کے اندر بھی. کہ کورٹ نے جیسے مثال کے طور پہ فارماسیوٹیکل سیکٹر میں میڈیسنس کے جو ریٹس ہیں وہ ان کے جو ہے ڈرگ سے اپروڈ ہوتے ہیں کہ منیمم ان کے مارکیٹ ریٹ کیا ہوں گے اور وہ کس طرح سے مارکیٹ میں سولڈ آؤٹ ہوں گے. تو یہ تو وہ چیز ہے کہ بائی وے آف ایویڈنس, کیونکہ ان کا جو ڈرگ پروکیورمنٹ کا جو مٹیریل کا کوٹا ہے وہ بھی بڑا اسپیسیفائڈ ہوتا ہے, وہ بھی ریگولیٹڈ ہوتا ہے بائی دی اسٹیٹ. تو یہ 2-3 چیزیں ایسی ہیں کہ جو کورٹ نے بائی وے آف ایویڈنس آپ ریٹس کے معاملے میں مثال کے طور پہ آپ کر سکتے ہیں ایویڈنس کی شکل میں.
وہ نارملی سنگل سٹیج 2 envelope کے کانٹریکٹ ہوتے ہیں. اس میں ٹیکنیکل سٹیج ہوتی ہے, فائنینشیل سٹیج ہوتی ہے. تو کیا اس فورم کے ذریعے یا آپ کی بک کے ذریعے ہم کوئی سجیشن فلوٹ کر سکتے ہیں کہ جب ٹیکنیکل سٹیج پہ جو بیڈر ہوتا ہے اسے اگر کسی بھی بائسنس کی وجہ سے یا کسی وجہ سے ڈسکوالیفائی کر دیا جاتا ہے تو جو پروسیس ہے وہ سٹاپ نہیں ہوتا اور وہ فائنینشیل اوپن ہو جاتا ہے. اور ونس فائنینشیل اوپن ہو جاتا ہے تو وہ باقی بیڈر ایکسپوز ہو جاتے ہیں, ان کے فگر سامنے آ چکے ہوتے ہیں. تو اس وقت چاہے اگر گریونس ریڈریسل کمیٹی میں جائیں یا ہائی کورٹ میں جائیں یا ریویو میں جائیں, پٹیشن میں, جس بھی فورم پہ جائیں, تو ان کی آپ ججمنٹس یا ڈیسیژنز دیکھیں تو وہ یہی ہوتا ہے صرف کہ چونکہ جی اب فائنینشیلز اوپن ہو چکے ہیں تو اب اس وقت ٹیکنیکل اسٹیج پہ رانگلی ڈسکوالیفائی کیا گیا, رائٹلی ڈسکوالیفائی کیا گیا, ہم اسے کنسیڈر نہیں کریں گے. تو اگر ٹیکنیکل کوالیفیکیشن اور ڈسکوالیفیکیشن فائنل نہیں ہوتی جب تک, اس وقت تک اگر فائنینشیل اوپن نہ کیا جائے, کیونکہ یہ میرے خیال میں اس میں پرووائڈڈ نہیں ہے لا میں, یا آپ نے کمپیریٹیولی دیکھا ہوگا تو کائنڈلی اس پہ گائیڈ کریں. تھینک یو.
دیکھیں پروکیورمنٹ رول, اگر آپ کمپلینٹ ریڈریسل کمیٹی میں جاتے ہیں تو اسی میں ایک پروویژن موجود ہے کہ جیسے ہی کمپلینٹ فائل ہوگی تو ایک ڈیفالٹ انٹرم اسٹیج جو ہے آپریٹ کرے گا. یہ پروویژنس پہ تو موجود ہے لیکن یہ پریکٹیکلی جو ہے یہ بڑا ایک چیلنج ہے. اس کے لیے جو مطلب میں نے ایک چیز دیکھی ہے کہ موسٹلی آپ کو ایک اسٹریٹجک لیٹیگیشن پہ فوکس کرنا پڑتا ہے. امیڈیٹلی آپ کو اگر مثال کے طور پہ آپ نے کمپلینٹ فائل کی ہے اور آپ کو اس کا اسٹیٹس کنفرم نہیں ہو رہا کہ جو پروسیس ہے اس کو روکا گیا ہے یا نہیں روکا گیا ہے, تو اس کا یہاں پہ ایک ہی حل یہ ہے کہ آپ اس کو جو ہے ایک نوٹس دے دیں ان ایڈوانس کے. اگر مثال کے طور پہ میری کمپلین آئی ہے اور آپ کو اس پہ جو ہے آپریشن کو اسٹاپ کرنا پڑے گا, اگر وہ اسٹاپ ہوتا ہے, اس کا جواب آتا ہے تو دیٹ از فائن. اگر اسٹاپ نہیں ہوتا تو آپ امیڈیٹلی ہائی کورٹ کو کانسٹیٹیوشنل پروویژن جورسڈکشن میں چیلنج کر سکتے ہیں اس کو کہ آئدر ایٹ لیسٹ ٹو سیکیور یور انٹرسٹ کہ بھائی یہ اتنا تک نہیں بتا رہے کہ یہ جو ہے اسٹاپ ہوا ہے یا نہیں ہوا ہے. کیونکہ اگر آپ اس کو ان کے ہی آسرے میں چھوڑ دیں گے تو اتنے کئی سارے ڈیسیجنس ہیں, آخر میں وہ انفرکشس ہی ہوئے ہیں, اور اس میں یہی آپ والی بات کہی گئی ہے کہ بھائی اب چونکہ یہ بھی ہو گیا, وہ بھی ہو گیا, اور یہ بھی نہیں ہوا, وہ بھی نہیں ہوا, تو وہ جو آتا ہے کورٹ میں وہ خالی ہاتھ ہی واپس جاتا ہے. تو اس کا طریقہ یہی ہے کہ موسٹلی مینلی یو ہیو ٹو ریلائی آن دی اسٹریٹجک لٹیگیشن, کہ آپ فوری طور پہ کورٹ سے اس معاملے پہ آئے مطلب رجوع کریں, کیونکہ اس اسٹیج پہ افیکٹو تو کانسٹیٹیوشنل پٹیشن ہی ہو سکتی ہے, سود تو آپ فائل نہیں کریں گے کہ وہ اس نے اس لیے کہ وہ کہیں کہ وہ اس کو روکے پروسیس کو پورے.